All right, joining us this morning is UP College of Law Senior Lecturer Attorney Amando Vergil Ligutan. He's the lead counsel for the third impeachment complaint against Vice President Duterte. Good morning to you, Attorney Ligutan.
Karen, good morning.
All right, so let's talk about first the petition. Give us an overview of what do you believe will convince the Supreme Court to reverse its decision?
Okay, so the only thing that could convince the Supreme Court into reversing its own decision, it's its acceptance that it could have committed what we call, Karen, factual errors in its decision. That is the only thing. That is the only thing that could open up the minds of the Supreme Court justices into entertaining an idea, an improbable but not impossible idea of reversing itself. Maybe the question is, what is that factual error that it could have committed? It's so simple. Logic will tell us that one thing could bar another if that thing comes ahead of the latter. I have to repeat that. The only means by which one could bar something is that if the former comes before the latter. Now, if we look at, Karen, the decision of the courts, the logic is simple. Since the House of Representatives purportedly enacted on the first three impeachment complaints, including the third one that we filed, the Supreme Court said that is tantamount to a dismissal. Since they archived the three impeachment complaints, they amounted to the dismissal of the three impeachment complaints. And because of that, it will bar the fourth impeachment complaint that was filed by the House of Representatives. So if we follow the logic of the Supreme Court, it's like saying that the quote archiving unquote of the first three impeachment complaints happened before the filing of the fourth rather. You know, Karen, I was there. I was a witness to the events inside the House on February 5, 2025. And it was so clear to me that what happened was there was first the decision of the plenary of the House of filing the fourth impeachment complaint and having it transmitted to the Senate before the archiving of the first three impeachment complaints. So the question is simple. If the fourth impeachment complaints filing came ahead of the archiving of the three impeachment complaints, how could the archiving bar? How could it bar the filing of the fourth impeachment complaint? And you know, it was pointed out by...
I wanted to ask you, Attorney Ligutan, what's more disturbing at this point is why would the Supreme Court get that wrong?
Yes,
it's such a simple fact.
No.
Why would they get that wrong? Kumbaga, ang Supreme Court ba ay nabiktima ng fake news?
All right, so that's a good question. But in fairness to the Supreme Court, Karen, the decision plotted out, so to speak, the events on that day. The decision correctly plotted the events on that day. So the decision said the archiving happened after the filing. But the problem is they laid out the correct chronology of events on that day. But the assumptions, with all due respect to the Supreme Court, the assumptions they elicited from the facts that they stated is faulty. Is faulty, exactly what we have just discussed, Karen.
Okay. Was the decision, do you believe, affected by the fact that the Supreme Court did not ask for oral arguments with this particular case?
Yes, I think, again, that's a keen observation, Karen. You know, for cases, with all respect, less important than an impeachment of the Vice President, why is it that the Supreme Court's wanted to hear from the parties? Why is it that the Supreme Court wanted to hear from what we call the friends of the courts? But why is it that in this case, as monumental as the impeachments of the second highest public official of the land, why did they not do that? So that is an observation that I share with. An oral argument, exactly what you just said, Karen, could have trashed out, could have prevented this, what we call factual errors that the Supreme Court may have committed, Karen.
Okay. Now, if the facts are clear based on your petition, I'm sure you pointed that out clearly. The House records would bear it. What if the Supreme Court ignores the facts that you have put out in your petition? Where would you go? In other words, what if the Supreme Court stands by the wrong facts,
Yeah, it
the
would.
information that it used as basis for its decision? What do you do then?
Okay, so technically there's nothing that we can do, but it wouldn't stop us from criticizing the Supreme Court decision. Karen, it will be an unfortunate incident of factual errors being, quote, cemented, unquote, into jurisprudence. And this decision that could be based on factual errors would be read by generations of law students, of magistrates. So it's like cementing factual errors into jurisprudence. That would be an unfortunate incident to happen, Karen. Karen, I would like also to point out, I heard what Attorney Francisco mentioned earlier. He said, and he was like convinced of what he was saying, that there was inaction on the part of the House. He said that it is unjustifiable. Of course, I'm paraphrasing. It is unjustifiable for the House of Representatives to have enacted for not acting, so to speak, on the 3 impeachment complaints. That's wrong. Why? Because the only way that we can conclude that the House was violating, i.e., not acting upon the first 3 impeachment complaints if they did not do that within the allowable period set in the Constitution. The Constitution is clear. The House had 10 session days. Repeat, 10 session days. And the question is, did they endorse to the order of business the 3 impeachment complaints? They did within 10 session days. So how can we accuse the House?
And that's been determined by the Supreme Court themselves, right?
Yes. That's why, for me, it's kind of troubling for a lawyer, with all due respect, to be saying that the House did not act on it, when in fact the House did within the period. So it's like the House maximizing the period provided by the Constitution. Is that wrong? No. Is that legal? Yes, perfectly. Karen, I would like to point out also that, in fact, that's what the Supreme Court impliedly is saying in the Gutierrez case. Repeats. In the Gutierrez case, that's what the Supreme Court said. You should wait. You should wait for the right moment in filing the impeachment complaints, because it's not a simple matter. You ought to come up with the best version of the impeachment complaints. That's why it's in the Gutierrez case. The Gutierrez case is impliedly saying you have to come up with the best possible version, and the House did. So, the conclusion is simple. The question is straightforward. Did the House, when it impeached the Vice President on February 5, follow jurisprudence? Yes. Did it follow the rules applicable at that time? Yes, it was Francisco. But it just so happened that the Supreme Court came up with its own new guidelines in 2025. But it is unfair for the Supreme Court to impose it on an act that is already done. So if we will push the argument further, what would happen then to the impeachments of then President Estrada? What would happen then to the impeachments of then Chief Justice Corona? These cases just followed the rules applicable at that time. Same with what the House did on February 5. So it is unfair. It is unfair, Karen. Karen, I would like to point out one more thing.
Okay, attorney, do you think that it is a factor, frankly speaking, that most of the Supreme Court justices right now sitting were appointed by former President Duterte?
I don't think that's a factor. I don't think that
Do
is.
you don't believe that's a factor in the decision? I
Yeah.
mean, you do have Justice Leonen appointed by the late President Aquino. He would be the most senior at this point, right? But most, I believe, if not all the rest, were appointed by former President Duterte.
Yeah. So, but I do think that is a factor. I still
Why
believe.
not? Why isn't that a factor for you?
Okay, because
Why isn't humanity a factor? The human bias. Why is that not a factor for you?
so I cannot say that. Unfortunately, I have no basis in saying that, Karen. So I cannot say that. I have no personal, professional basis in concluding that. I still believe in the good judgments of the Supreme Court in the same manner, Karen. That's upon reading the 5 motions for reconsiderations, these justices
But then
will
if the
exercise.
Supreme Court had good judgment, why would they make a decision based on completely something false?
All right. So that's the reason we have.
Where would good judgment be there?
Okay,
If
so,
you say they have good judgment, why wouldn't they call for oral arguments? Why wouldn't they double check facts? Why
Because
wouldn't they do that? It doesn't sound like good judgment to me at this point.
Because they could do that, Karen. They could do that. They could just
So is
decide
it
a
good
case.
judgment, or it's just the fact that they can do it?
They can
That's
do it.
different.
They can do it. They can do it. They can decide
So
not to hold
did the
oral
Supreme
arguments.
Court overreach?
Yes,
Because
it
the
did.
Philconsa said that in this case, the Supreme Court gifted themselves
Yes.
with extra powers
Yes.
that were overreaching to the Constitution.
I
So
agree
do you
with that.
believe that the Supreme Court
I agree with that.
overreach? You do.
Yeah, so because there's a line in the decision that for me, it's kind of it troubles me. It troubles me that the Supreme Court arrived at that conclusion. And what is that, Karen? In one sentence, the Supreme Court said, if there is already a filed impeachment complaint under the first mode, i.e. through a private citizen or a member of the House, all right, it deprives the House of Representatives of resorting to the second mode, that is for them to
Exactly.
file. For me, that is the linchpin of the entire Supreme Court decision. You know, I was curious, I was interested, so I readily looked into that part and checked if the Supreme Court cited any legal basis. Karen, none. The Supreme Court did not cite a single law, jurisprudence, principle that would back its decision to say that there is now this priority. There's now this priority between the two modes. For me, that is the linchpin of the entire Supreme Court decision. And it is based on what the Supreme Court wanted to say at that particular moment, at this particular case involving this particular person. That is so unfortunate. It goes against the grain of the Constitution. The Constitution, Karen, is clear. It is the House's sole prerogative to initiate impeachment proceedings. Now, if the Supreme Court is saying that the House cannot exercise discretion, that is overreach. That is overreach, Karen. With all respect, that is something that really troubles me as a law professor, as a student of law. Because now the impression is like it's hard now to impeach an impeachable official. And that is not the design of the 1987 Constitution. The 1987 Constitution is a compromise between the two previous constitutions. And the compromise is that it should not be too easy.
Yes.
Definitely, it should not be this hard.
Yes, very good point. Very good point. So the 1987 Constitution is a compromise of both, that it shouldn't be too easy to impeach an erring public official, but it should not be too hard. But
Yes.
now with the Supreme Court decision, you have to, they call it due process.
No.
Do you believe in that?
No, I don't
What they
believe
gave
in
was
that.
due process.
I don't believe in that. For due process to apply, Karen, there must be two elements. One, there must be the involvement of life, liberty, and property. Now, simple. The question is simple, straightforward. Is being the vice president's life, liberty, or property? No, it's not. This is the same Supreme Court that said public office is not a right, it is a mere privilege. All right? Right. So if it is a mere privilege, it means it could be taken away from you anytime because you don't invest anything. It's not life, it's not liberty, definitely it's not property. Now, if it's not either of the three, then what is the vice president deprived of? Nothing. Now, the basis for the Supreme Court said, but, impeaching a public official would result to what they call professional and reputational consequences. Repeat, reputational and professional consequences. It's like saying they will be embarrassed by this whole thing. But that is exactly non sequitur. It doesn't follow, it doesn't, with all due respect, the same Supreme Court said public officials should not be onion-skinned. Repeats, this is the same Supreme Court that said public officials should not be onion-skinned. And this should apply more to the second highest public official of the land. Second point, was she deprived of anything when she was impeached? No, she was not. She received the same hefty remuneration. She occupies the same position. She was not deprived of anything. So 2 points. If she was not deprived of life, liberty, or property, and if she was not deprived anything at all, then when would due process clause of the Constitution apply?
Okay, now, attorney, my last question. Given there is a motion for reconsideration, you are are you the fifth?
Yes, we are the fifth.
Imagine that you're the fifth. Could you appeal in your motion that the Supreme Court call for oral arguments before they decide on the MR? Is that possible?
Yes, it's possible for oral argument. So that would be an avenue for the Supreme Court to address the grave concerns raised by no less than the previous magistrates of the Supreme Court of the land. It's not surprising that these former justices would come out in the open, like come out of retirement and speak their mind, because they noticed these grave errors of facts and law that the Supreme Court may have committed. So I would exhort the Supreme Court to please listen to your predecessors, because they are making sense on these particular matters, Karen.
Okay, thank you so much, Attorney Ligutan. And I think for our viewers, I think it's very important to remember that the Supreme Court is not infallible.
It's
At
not.
the end of the day, they are human beings, just like
Yes.
you and me. Well, they are lawyers. I'm not a
Yes.
lawyer, but they're humans. They can
Yes.
make mistakes.
Yes.
You can make decisions out of personal biases too. But at the end of the day, the Supreme Court is not infallible.
It's not.
It does not mean they do not commit mistakes.
It's not.
That's an important thing to remember.
I would like to add 1 point. It's a saying. The Supreme Court is not final because it is correct. It is correct because it is final. But we can do better than that, Karen.
All right. On that note, Attorney Ligutan, thank you for joining me this morning. Thank you.
Good morning, Karen.